Chief Justice, Your Honor, may it please the Court. My name is Selena Percow, and I represent the petitioner, Mr. Miles Maverick, in this case. We respectfully ask this Court to reverse the lower court's decision for the following two reasons. First is that the respondent, the United States, their actions constituted a search under the Fourth Amendment. The second is that the respondent lacked the sufficient probable cause for a valid issuance of
What
the
is the
search warrant.
test to determine probable cause?
Yes, Your Honor. The test to determine probable cause is laid out in Illinois v. Gates. This case stated that to test for sufficient probable cause, you have to look at the totality of the circumstances and the evidence presented in order to determine whether there is sufficient probable cause. Would you like a brief recitation of the facts?
Yes, go ahead.
So, in this case, the respondent utilized a third-party gotcha surveillance camera to track Mr. Miles Maverick's movements and used the information gathered from the surveillance cameras to issue a search warrant, which issued a search warrant of Mr. Maverick's home, and that led to Mr. Maverick's arrest. The first issue is whether the actions of the respondent constituted a search of the Fourth Amendment.
Well, Mr. Maverick was in a public place. Why should he be protected by the Fourth Amendment?
Your Honor, in Katz v. United States, the court stated that the Fourth Amendment does not protect places, the Fourth Amendment protects people. So although Mr. Maverick was in a public place, he still had the protections of the Fourth Amendment. Katz v. United States also sets out the test to determine what constitutes a search under the Fourth Amendment. The first prong is whether the defendant had a subjective expectation of privacy. And the second prong is whether society is willing to recognize that expectation as reasonable. Here, Mr. Maverick manifested his expectation of privacy through his actions. He conducted business deals, he spoke with clients, he spoke with business partners, potential business partners, all in public while retaining his expectation of privacy. And society would recognize that expectation of privacy as reasonable. Having conversations in your car, conducting business in your car, these are areas in which society maintains that there is some sort of expectation of privacy. Secondly, the respondent did not have sufficient probable cause to issue the search warrant. The agent that gathered the information and the evidence for the affidavit for the search warrant used the information from the gotcha surveillance cameras. This information included Mr. Maverick in a grocery store parking lot, Mr. Maverick in a Taco Bell parking lot, and having a conversation with undercover officers in a cafe. None of these locations link Mr. Maverick to his home, link Mr. Maverick to conducting business or illegal business out of his home, and they do not link Mr. Maverick to containing illegal substances in his home. This is all in public. There is not a close enough link to Mr. Maverick's home with the evidence that was presented. And that is how you analyze it that is how you can analyze it according to the test, which was laid out in Illinois v. Gates, the totality of the circumstances test. In addition to the fact that it's well known that people who conduct this type of business generally have a secondary location, which is not their primary residence, where they conduct business, this kind of business from, which does not link, which adds to the fact that there is not a strong enough link to Mr. Maverick's home and the evidence that was presented in the affidavit for the search warrant. So allowing this ruling of the lower courts to stand would create a dangerous precedent. It would be an overbroad and overscoping precedent, which would be dangerous for the future of what can constitute as a search warrant and the protections of the Fourth Amendment. For the foregoing reasons, we ask you to reverse the lower court's decision. We find that Mr. Maverick did not have the protection of the Fourth Amendment, and there was not a sufficient probable cause for the search of his home. Thank you.
Yeah, that was good.
I think this is more true.